Virginia, Mr. Cline, for his questions.
Thank you, Mr. Chairman. Thank our witnesses for being here. Ambassador Shea, let's start with a question about the trustworthiness of the Chinese government. How would you rate the trustworthiness of the Chinese government and Chinese Communist Party with respect to IP rights, especially considering the conduct that's been documented in the USTR Section 301 report in recent years?
I would say that the trustworthiness is nil. Each year, the USTR issues an annual report on China's compliance with its WTO obligations. The Biden administration put out a very strong report saying China's compliance is poor, and it goes through the litany of violations of subsidy notifications and market access requirements. And that's why I find it so intriguing that we would rely on a footnote in a ministerial decision that indirectly references a binding commitment by an official at the WTO, at the General Counsel. It does not seem like a very powerful commitment to me.
What do you make of the Chinese government's silence on whether they'd give similar assurances with respect to an expansion of the waiver to therapeutics and diagnostics?
Well, I think there's a possibility that they will seek that. I also think we should be passing, the Senate should take up the PRC is not a developing country act. I know it passed by 415-0 here in the House of Representatives. As I read that footnote, it suggests it treats China as a developing country, even though it allegedly makes a binding commitment not to seek a waiver. But I think if we had that as the policy of the United States, that we do not treat China as a developing country in international agreements, international organizations, that would really, I think, help stall an effort for China to seek a waiver on other matters.
Now, how would you compare the current debate at the WTO as to special IP waivers for COVID-19 with the debate around TRIPS flexibility for HIV/AIDS drugs from 20 years ago?
I wasn't really paying attention 20 years ago, but I mean the issue. I think when India and South Africa first circulated the TRIPS waiver proposal, no one, I think, took it seriously. It happened sort of at the end of my term at the WTO, but it suddenly got legs. I mean, and I would say that South Africa and India are also countries that, under a proposal we put forward at the WTO on special and differential treatment, they would also be covered because they're members of the G20. India is a huge economy. So why are they not abiding by all the rules at the WTO? Why do they have a right to automatically claim special and differential treatment?
Before the WTO's IP waiver for COVID-19 vaccine patents was put into place, many noted that the TRIPS agreement already provided flexibilities for member nations to implement compulsory licenses for public health emergencies, but no member nation tried to use those flexibilities before the IP waiver was adopted. Do you think that the IP waiver was needed considering existing TRIPS flexibilities?
No, it was certainly not needed.
And what are the differences between the IP waiver and the TRIPS flexibilities available before the waiver?
Under TRIPS, as I think Professor Bush cited in his testimony, there has to be an effort to engage the patent holder before you exercise a compulsory license. It has to be under extraordinary circumstances. You can't export the vaccine. So it expanded. There's a compulsory licensing regime in TRIPS, and what the TRIPS decision did was expand this already reasonable system to allow the use of compulsory licenses in extraordinary circumstances.
Professor Bush, you noted that the notice requirement was exactly the wrong requirement at the wrong time. Can you elaborate on that?
The idea that there wouldn't have to be a discussion with the patent holder is not only wrong for innovation, but obviously wrong for the generic provider, which under voluntary licenses is typically getting a tech sharing arrangement. So it really doesn't make a lot of sense, even if you believe that IP is the link. The problem is that there is no evidence that IP is the link. Now, let's not correlate two things here. Everyone wants cheaper drugs. Compulsory licenses don't necessarily do that. So this is, as my colleague said, a solution looking for a problem. We actually have evidence that compulsory licensing doesn't come close to certain voluntary licensing prices. So there's no magic here. It's not necessarily the case that a compulsory license eases the burden in terms of price. And as I pointed out, even when these drugs have been made available for free, that has not led to more jabs and arms.
Thank you.
Thank the gentleman. We now recognize the ranking member, the gentleman from Georgia.